Okay, thank you and welcome back. And I would now like to welcome to the meeting Reem Alsalem, UN Special Rapporteur on Violence Against Women and Girls. And if I can invite Reem to make a short opening statement, please.
Well, first of all, I'd like to thank you really for having me. Even though it's late in the process, I very much welcome the opportunity to elaborate on the letter that I had sent and also on the issues that I have raised. Can you hear me? Can you hear me?
Yes, Reem, we can hear you.
Okay. Many of the issues that I had mentioned echo points made by feminist organizations and victims. So in a nutshell, I wanted to emphasize that that of course the issues I have raised are not about legal recognition or it's being a right in international human rights law. The issue is that self-ID has no established basis in international law, and while of course the reform can be based on self-ID, there is no basis in international law to have an unhinged self-ID process. I think it's very sort of logical and legitimate to expect that any process where there will be access to a group of individuals that may be vulnerable, such as women and children, by sex offenders are firewalled by safeguards or have safeguards attached to them. And likewise, also any process where you would have an access to additional rights would have to also be regulated. And on the first one, I would say that our experience as women born female is that actually those violent males who can take advantage of any loopholes will do so in order to get into women's spaces and have access to women. Our experience as women born female tells us this. And of course, also when it comes to policies where there is safeguarding expected, it does not mean by any means that therefore we are saying that everyone will commit offences. So, for example, you have safeguarding policies at schools, you have safeguarding policies in hospitals, at police stations. And it does not mean that all police officers, if there is a case of a police officer raping a woman, that they are rapists. The issue is that we have to make sure that there is protection in place for any policy where there is access to women and children. So I'm just saying that, all I was saying through this letter is that there are a number of issues that still need to be worked through when it comes to the GRA reform, and that this is now a good opportunity to do a comprehensive adjustment of the GRA, because there are issues preceding the current reform that have to be addressed. One of it is its relationship to the Equality Act. One of it is also the impact on single-sex spaces, including the reasons why women self-exclude. And so it is just taking the time to do this properly and not to rush through it, while at the same time ensuring that we look at the totality of rights. So for women in all their diversity. And I do believe that it doesn't have to be a zero-sum game. You can actually work out a system where you look at the coexistence of rights for different groups of women, because that is also what an intersectional approach is all about. Thank you.
Thank you, Reem. If I can just now ask Maggie to go to questions with Maggie first.
Thanks very much, Joe, and good evening, Reem. Thank you very much for joining us this evening. I appreciate you making the time to be with us. I've got two questions for you, if I may. Firstly, I would like to explore your reflections on the Council of Europe Commissioners for Human Rights, Dunja Mijatović's report, where she says, and I quote, that both government officials and certain parliamentarians have actively contributed to an intolerant and stigmatizing discourse. And that's the end of the quote, where she critiques the culture wars surrounding trans rights in Scotland. And she also says in that report that trans persons in the UK face increasingly hostile and toxic political and public discourse. Can I ask you what's your thoughts on those on her report in general, but on those 2 points specifically, given the context within which we are discussing and debating this bill?
Yes, thank you for that question. I must say that one of the main problems is precisely that when there are groups of women coming forward trying to reassert the sex characteristics and the discrimination they endure based on sex characteristics, and try to also ensure protection for single-sex spaces, they are accused of hate speech, they are accused of intolerance, they are accused of being transphobes, they are lumped together automatically with all sorts of other movements, be it, anti-abortion, be it this, be it that. And therefore, there is no space for them really to also practice their human right of freedom of expression. So as a result, it also negates the opportunity for these groups of women really to also express and reassert their needs based on their identities, their profiles, which is something very legitimate. The international human rights law actually does not negate the protection of sex characteristics, does not erase them. More recently, we look at discrimination and violence against women based on, gender identity, but also sex. And we cannot conflate the two, and we cannot say that one equals the other. So while I do, of course, recognize that LGBTIQ persons do face discrimination, including in Europe, and do face intolerance, we have to address that, but it does not all mean that, therefore, we can deny others the right to express their needs.
Okay, thank you for that. I mean, I think I asked specifically on the impacts of the culture wars that trans people are on the brunt of and experiencing. And you talked about the freedom of expression. We've heard elsewhere in our evidence that freedom exists up to a point where it doesn't impinge on the freedom of other people to exist. And I think that's an important statement to make. But you spoke then, and in the letter that you wrote last month, you spoke about the need to listen and to take account of and evaluate the responses in the consultation processes, in the scrutiny processes that Scottish Government and the committee has undertaken. You said in your letter, consultations were not perhaps sufficiently inclusive of other groups of women and organisations that represent them. And I'm just wondering, given that we've heard from the Scottish Women's Aid, from Rape Crisis Scotland and some of their network members, from Engender, from the Scottish Women's Rights Centre, all of whom support the reforms that are within the bill. I'm interested, which other women's organisations in Scotland, in the domestic Scottish setting, have you approached, or who have approached you? Where is your evidence for calling for this bill to have, as you called it, a comprehensive refresh? Thank you.
Yeah, I wanted first to come back to your earlier comment about this being about culture wars. I actually don't think this is the right way to characterize this. This is about really a human rights issue, fundamental human rights issues about how we can ensure the coexistence of rights of different groups in society in a dignified and equal way, without one really erasing the other. For your other question, I think much of that is actually mentioned in the reports on the sessions that the Parliament has had, where a number of Scottish organisations have come forward and have said, either they haven't been consulted, there have been victims that said they haven't had access really to the parliamentary committee. There have been detransitioners who have been, asked to come in very late in the process. And one thing is, of course, participation, which may or may not have happened to varying degrees. But what has been clear to me also from the flurry of letters that I received actually after sending my letter is that they have not been sufficiently digested, taken into consideration and considered. These persons may have been consulted, but there is a difference between being asked for your opinion and feeling that you're not heard, or that whatever you say actually doesn't matter.
Okay, thank you. Just two quick points to follow up on. The reference to culture wars comes from the Council of Europe's Commissioner for Human Rights. So I think that's clearly her statement. And I think, whether or not I agree with it, I happen to agree with it. I think just to be clear that when she says government officials and certain parliamentarians have contributed actively to this intolerance and stigmatizing discourse, within the cultural wars context, that's a direct quote from her report. Just on the organisations that have been in touch with you, you spoke you wrote in your letter about, very clearly listening to organisations and survivors of violence. And I think it's worth just restating that the Scottish Women's Rights Centre, Rape Crisis Scotland, Scottish Women's Aid, who all directly support victims of violence, victims and survivors of gender-based violence, are all supportive of these reforms. But I appreciate time is short, so I'll leave it there, Joe. Pass over to you.
Thanks very much. If we can now go to Pam Gossel, please.
Thank you, Convener, and good evening, Reem. In your letter, you mentioned that ring-fence funding should be available for service providers that are sex-based and those that are gender-based. While that was determined that it was out of the scope of this bill, do you think it'd be helpful for an amendment to be made for the Scottish Government to at least review the impact of this bill on funding for single-sex services and set out any further steps it considers necessary following the review?
Absolutely. And in fact, one of the reasons why a pause would be useful is actually to carry out some of the impact assessments that have been missing, not only in Scotland, but also other countries that have perhaps adopted legislation on self-ID. Because what you can see really across the board is that there haven't been impact assessments really on different groups of women that may have been affected by this legislation, not just those that may, acquire a gender or gender reassignment certificates or self-ID, but also those that are, other groups of women, particularly those in single sex spaces, including prisons, including victims, shelters for victims. And so that would be very useful. precisely also to collect data that includes not only gender, but also includes sex. And I'm afraid there is an increasing deprioritization and neglect of collecting sex data. And that, of course, leads to conflation of then data results. So, for example, if you see that, for example, inmates in a prison, the number of, let's say, sex offenders in prisons has gone up that are women, but you don't know that they are born male, for example, then you might draw the wrong conclusions. In addition to that, I think what is really important, and I had suggested this to government, is that why not take this opportunity really to also undertake amendments in the GRA that are problematic and that already exist. So, for example, if you look at the exceptions, and especially with the last ruling by the judge, I think it's by Lady Halden, I think, which shows that males with the GRC are considered legally female. I think that shows that there is an impact, therefore, with the reform on the Equality Act. So why not also, first of all, wait to see actually what the government, the UK government thinks, how are we going to actually resolve this issue, as in the Equality Act, the definition of sex is still understood to be biological. But also, if you look at the exceptions then in the GRA, I think you probably have to allow also for information to be disclosed when it comes to decisions about access to single-sex spaces, because right now that is not explicitly stated, and that is causing a lot of problems for service providers to assess actually, who to let into a single-sex space. So there are things in the GRA that are already problematic, even without this latest round of reforms, that could also be addressed before we move to even another set of reforms that can be problematic.
Thank you, Reem. Just on that, another question. Since you've published your letter to the UK government, several parties have reached out to speak with you to gain a deeper understanding of your intervention. And at the meeting which I was in attendance, you briefly mentioned that in Belgium, a mechanism used to safeguard the bill and reject applications is legislated for under public order. Can you talk about that in further detail with the committee today, and perhaps outline any other international examples of safeguards that have been used to make the process more robust in the face of bad faith actors?
Yeah, so as I said, I think we need to take any examination of other countries' legislation with a grain of salt. Because each country context is very country specific. I think, as I said before, Scotland is part of a union, whether, we like it or not. And there is the Equality Act, and the relationship of any legislation that happens in Scotland has to be assessed to the wider UK territory. So basically what happens in Scotland doesn't stay in Scotland. And we've heard also, the comments by Westminster on that, and also the implications for movement. So I think really we should continue to look at the needs and requirements and situations of Scotland and the UK. So that's number one. Number two is, I don't think any of us is really an expert on how other countries have done their processes, what has gone well, what hasn't, the extent of consultation. I mentioned one thing across the board is the lack of data, the lack of impact evaluations. I have seen, for example, even though, for example, the Belgian legislation, and I'm also Belgian in addition to being Jordanian, looks at, for example, the possibility to reject an application based on public order. By I think it's the prosecutor. It's clear that they have also not carried out an impact assessment, and when they collect data, they don't collect data based on sex, So yes, is it good that they have sort of some additional safeguards there when it comes to also, self-ID by children or even acquiring, a gender recognition certificate? There are different sort of models depending on, whether the parents agree, how old the child is, etc., etc. So they've come to something, that makes sense for them. But I think we have to look at this holistically, and we have to, again, bring this back to Scotland and the needs of everyone in Scotland.
Thank you, Reem, obviously for emphasising how important the collection of data is in the reviewing it. And that is some of the amendments I've put forward. So thank you very much.
Okay, thank you. And can I go to Fulton McGregor, please?
Thanks very much, Convener, and good evening, Reem. Thank you very much for coming to do this today. I know it was quite tight scheduling as well for you. You'll have heard a wee bit, I think, of the last session there where we heard from Victor. And he stated in his letter to us he was quite concerned about the misrepresentation of the existing consensus within the bodies and entities of the UN human rights system. I wonder what your take is on this consensus. How confident are you that your views are also those of the bodies and entities of the UN human rights system?
So as I said, there is a consensus that persons have access, should have access to legal recognition, and that this should happen, in a way that is consistent with the fundamental principles of dignity, and also, be consistent with human rights, etc. But as I said, I don't think there is consensus. I have not seen consensus that countries should adopt a self-ID model. I think that it can be based on self-ID, but there is no proof anywhere that it should be unhinged, that we should have a complete disregard for safeguards. And often there is a reference to the Yogi Karta principles, which, by the way, are not binding, and which also, which really erased also the issue of sex completely from their considerations. So when it comes to our opinions or positions as special rapporteurs, we, as you know, are independent experts. We represent our views. We try to base our opinions on, on established human rights law. But our opinions are not, let's say, firm, binding positions on anyone other than ourselves. And in fact, there are instances where we disagree with each other. So we try to develop jurisprudence and push the envelope, but we cannot say that it is established jurisprudence, or that we speak on behalf of the UN, or that we represent the UN.
Thanks very much, Adrian, for that clarification. Sorry, Convener, am I okay for another question?
Yeah, I think you're okay, yeah.
Yeah, thanks very much, Convener. I know that time is tight. We've heard on both sides, if you like, if you want to call that, both sides of this debate, a lot of talk about needing empirical evidence. And I know that you describe needing that evidence in the context of safeguarding and risk management protocols. Reem, I'm wondering what evidence from other countries that you've got, because I know in your answer to Pam Gossel there, you spoke a bit about there not being a lot of data collected across certain sort of areas. So what evidence is it that you think is there that has informed your own views and own interventions on this issue?
So I mean, one thing is the lack of a concerted effort to do impact assessments, to collect data based on sex. As I said, I do think there is evidence. There is evidence, in different reports that we see in the media. For example, if you go to certain managers of prisons. They will have evidence where violation of a single sex sanctity for female prisoners has caused problems. The issue is, of course, it's not consolidated, it's not brought together, it's not analyzed, and therefore you don't see the trends. For example, I was quite intrigued by the fact that I read in one research paper that since 2018, for example, there's been at least 30 cases in the UK brought forward by feminists, NGOs, women organizations, in which they tried to challenge the erasure of single-sex spaces and also, reassert the right to basically, to identification based on sex. And of course, if you don't see this all brought together in one place, you would say, okay, it's not really an issue. Women are not really raising this as an issue. There's no, what's the fuss about, basically. But it is an issue, and it is an issue for many. And we see this also in many countries across Europe and across the world. And a very small example is that since I've written this letter, I've been contacted personally by a number of women organizations, really in all their diversity, including trans women, that have said that this is a concern for them. Self-exclusion is a concern for them. They say that, the understanding of the need for dignity is not present, that it doesn't have to be contact-based sexual violence. If you have somebody in your space that will, look at you, that will flash you, that that you're fearing of being in their vicinity, this is also a form of violence. And I'm afraid that, being male, you may not, a male identifying as a man, you may not understand these issues. So it also comes down to who do you ask about these things and whose voices do we hear about these issues. Because of course, men do not go through these same experiences and therefore may not have a full understanding of the implications of something as simple as that, but as essential as that.
Okay, thank you. And we can now go to Pam Duncan-Glancy, please.
Thank you, Convener, and good evening, Reem. Thank you for joining us tonight and for engaging with us at this time. During our evidence session, some witnesses did raise similar concerns to those set out in your letter, whilst others, such as Rape Crisis Scotland, explained that single-sex services like theirs have never required a gender recognition certificate, nor asked someone to provide proof of any of their gender. And they also noted that their services have been trans-inclusive for 15 years. So have you had any discussions with single-sex providers in Scotland? And who were the organisations in Scotland that you engaged with on your conclusions in the letter?
So I just want to be clear on two things. First, I wanted to say that I'm still on mission in Libya, and I've been here for a whole week, and I wish therefore I had more time to really concentrate on this as much as I wanted to. But I'm sort of doing this under very strenuous circumstances. The other thing is I've engaged in conversations with anyone that has reached out to engage with me. So there's been a number of organizations. I really would like to also respect their privacy and confidentiality. So unless they come forward to say that they have met with me, my policy has been, or unless they agreed, my policy has been not to disclose this off the, just publicly like that. That said, again, many of them are listed in the notes or the report on the parliamentary sessions. You know who they are because they have spoken out about this issue. And we come back to the fact that even before this latest reform, you have a situation where it's very difficult for on-the-ground service providers to, decide what to do with somebody who is not female, even if they don't have a GRT, because of also the criminalization of disclosing information, because of the lack of funds available for single-sex spaces. And we've seen that, a high-profile person, I think last week, writer had, decided to actually fund a centre in Edinburgh because it doesn't exist, and because there is pressure on those that provide single-sex spaces not to do so. And by the way, this is not just in Scotland. You hear this also in Canada, where it's considered actually not acceptable if you want to protect that space because you're not inclusive, because you're not sensitive enough. And actually, that is not even the right issue, because we are saying single-sex spaces alongside gender-based. So we are not saying that we are going to abolish mixed sex spaces. These continue to exist. They exist in abundance, but the issue is to make that other option available to those who want it. And I was listening to your question about, for example, women belonging to religious minorities. I have to say it's really really any victim also, or anyone at risk of violence. It's not our job to second guess them or to question why do they feel this way. It's our job as states and as organizations to reduce the barriers for access. And if those barriers means having mixed persons of mixed sexes in there, then we have to find a solution. Because they are often among the most vulnerable. And this is what is required by an intersectional approach, is to look at the different groups that face more barriers to access services, that have higher rates of violence potentially, and to help them access the protection and assistance that they need. And to do that, we have to understand what reasons they have for making decisions. And if that reasons also includes mixed sex space, then we have to work on that without passing judgments and without saying that this is transphobic, or that it's hate speech, or they're not saying the others don't exist. They're not saying they don't have their needs. They're not saying definitely that they shouldn't have access to services. They're just saying we have specific needs and we'd just like to have a space for us.
Okay, thank you. Informing your view of the proposed legislation in the way that you set it out in the letter to the Cabinet Secretary, what consideration did you give to international examples that already have self-ID systems, and what evidence have you taken specifically on those?
Sorry, I don't understand the question. Could you repeat, please?
Yes, sorry. When you were forming your view in the letter that you wrote to the Cabinet Secretary, what examples or evidence did you look at from where self-identification systems have been used in other jurisdictions internationally, and how did that help inform your view?
So thank you for that question, because I want to come back to the reason of why I intervened on this. I intervened on it from the perspective of my mandate. So I'm not looking at this on whether persons are entitled to self-ID or not. This is, the issue of legal recognition, as I said, is something that I find is already established in international law. Self-ID is not. But the point of entry and what I've looked at in my letter is not whether there should be self-ID or not, is the impact of an unhinged self-ID without safeguards without appropriate safeguards on the access and enjoyment of protection and assistance by women in all their diversity that are either experiencing violence or at risk of violence. And if we look at it this way, then we'll also take into consideration, as I said, the extent to which they are included meaningfully in consultations, their views are taken into consideration, the impact of of certain policies on their access and the barriers, including self-exclusion. So then it becomes a different sort of entry point, I have to say. And I just want to, draw your attention to one thing. My colleague who spoke before me, and of course whose mandate this is, had in 2019 presented a report on the issue of data when it comes to, the presence of adequate data on the experiences of violence that LGBTQI persons experience. And he said very clearly, and I agree with him, that the fact that, data doesn't exist, let's say, on the violence experienced by LGBTQI persons doesn't mean it doesn't exist. And of course, we have to collect, or the state has to collect data very deliberately and very consciously. And I would like to invite us to, by analogy, then move this also to what we're discussing now. The fact that data doesn't exist or isn't consolidated, I think it exists, as I said, but isn't consolidated and isn't sought for, is not a reflection on that we don't have a problem. It's a reflection on the fact that nobody is looking for it, because we have victims and women organizations telling us, they've been telling us for many years now, and have told us again in this context that it is a problem.
Thank you for that. I just have one final question, Convener. Given the concerns that you've raised and that other people have raised, and to help ensure that public bodies, for example, in Scotland, deliver the reformed gender recognition process that we know trans people need, and understand their responsibilities as well to women and girls under the Equality Act, do you believe the Scottish Government should introduce guidance to give clear advice to public bodies and the wider public on how the Act will operate?
It should include guidance. Sorry, I'm sorry, because I can't hear you really well for the connection. Could you repeat?
Of course, I'm sorry. I was just saying, given some of the concerns that people have raised, do you think it would be helpful for the government to issue guidance in this area?
I think it would be helpful to issue guidance, but frankly, on its own, this is not enough. It's like a bandage solution to a much to wider and more systematic flaws with the process and with the draft legislation as it stands. So I would suggest that again we go back and we address all these different pieces, because they're all linked to each other, and not perhaps try to then suggest that there will be a magical solution to some of these issues by non-binding guidance. Some things have to be really clarified and spelled out in law. This is what women organizations and many victims expect. This is what lawyers also and experts expect and know that to reasonably, expect that we've seen this also in other legislations. So it comes back to, perhaps slowing down again and doing these things and looking comprehensively at what needs to be adjusted and what needs to be done, of which one of them could be also more detailed guidance.
Thank you for that. Are there's amendments in this area on the legislation that you'll be aware that we'll be looking at that this week? Are there other amendments that you think could be helpful in terms of reassurance?
So I just want to mention one area. I didn't mention it in my letter because I didn't have time to really delve into it, but I know others have talked about, which is lowering the age for children. So I'm not going to speak to that because it was not in my letter addressed to the governments. So I cannot speak on it, therefore, publicly. But I think that is a whole area really that needs to be looked at very carefully. As I said, Article 22 of the GRA, the exceptions, spelling out specifically that you can disclose information, for example, in order to make decisions about whether maintaining single-sex spaces is, legitimate and proportionate to a legitimate aim. I mean, there's a wording that is presented in there. And also, frankly, I mean, resolving this whole issue about, I think we're not out of the woods on that, whether, you know, sex, the definition of sex is biological or legal. This decision seems to suggest it's legal. You know, what does Westminster say? Will there be a legal challenge for that? It does certainly complicate more even access than a provision of services, and you know, based on that, because of course that decision means that that males with a GRC, according to Lady Halden's decision, males with a GRC are considered legally female. So the assertion by the government, or at least in some instances by the Scottish government, that there is no impact whatsoever by the GRA on, you know, in its new form on the Equality Act, is actually quite challenged then by this decision.
Okay, if we can now go on to Rachel Hamilton, please.
Thank you, convener, and welcome, Reem. I just wanted to pick you up on a point there that you said that you hadn't responded to in your letter, but you wanted to raise, which was around the that you said age. And I just wondered if you have concerns that around the UN Convention on the Rights of the Child that defines anyone under the age of 18 as a child, if you believe that that will have an impact, but also some of the views around a report called the CAST report.
Sorry, I couldn't hear the last bit, a report, and then I lost you.
Okay, I think we have lost Rachel. Yeah, so is Rachel? Sorry. Yeah, I think we've lost Rachel. We'll go to Karen Adam, please.
Thank you, convener, and thank you, Reem, for coming this evening. I'd like to ask you, Reem, in 2021, you joined with other UN-mandated representatives to write to Bulgaria to ask them to make gender recognition a more simplified process based on self-identification. And I'm just wondering, what has changed your mind this last year, and could you explain to us the evidence that prompted that?
Sure. So as I said, even here, I think legal recognition could be based on self-ID as long as there are safeguards. Now, when I joined this letter, it was a month after becoming a mandate holder. Now I've spent really half of my mandate, almost a year and a half. And while I still hold the view that it can potentially be done, but of course also the European Court of Human Rights defers, you know, defers the decision on how to go about legal recognition to the state. So, you know, if the state also would like to, include the principles of self-ID, again, as I said, as long as safeguards are included, then fine. So I'm not against it in principle. I at the same time, in the last year and a half, I've become more aware of the issues surrounding the application of unhinged self-ID issues. Now, if you look at the letter to Bulgaria, we just addressed whether, you know, it should be done or not. In hindsight, I mean, I wish I knew then what I know now, because I would have qualified really my joining much more. I would have, spelled out these issues about safeguards. And what I would definitely not have done is join a communication that says, that falls back on the Yogi Karta declaration, because frankly, now I know much more about the Yogi Karta declaration than I knew then, because also there are many who position the Yogi Karta declaration as being established human rights law. And it's very clear to me now that it isn't, and it's actually dangerous to look at it. I must say that there are other issues where, initially they were not on my radar screen. And of course, given that we are contacted by women organization victims, feminist organizations from all over the world, it also shapes and refines my understanding. And I'll give you an example. When I first became rapporteur, I did not really think that custody issues was such a big issue for women, and that in fact there were a lot of gender stereotypes and it could be used to perpetuate violence against women. But then over the year and a half, I've been exposed to concerns by women all over the world. And as a result, even though it was not on my radar and even though it was not intended, but I'm actually dedicating a whole report to it next year because I realized, or it has come to my attention, that this is really an issue. So I would say what happened now is a bit similar in that respect.
Can I just follow up on that? It's just to get some clarity on those points. You say if you knew now what you knew, or if you knew then what you know now, and there was some issues that came to light, and there were some organisations that came and spoke to you. But it's hard for me to get that understanding of where you're coming from, just because you've given an example of custody, but I haven't heard an example or evidence of why the change in opinion now. Do you have any examples that you could perhaps share with us?
Yeah, it's not a full change. As I said, I still believe, and I mean, whether I believe it or not is irrelevant. It is established principle in human rights law that persons have a right to legal recognition of their gender identity. I think that is clear. It can be possibly based on, it has to be.
Reem, I think we're losing you. Could you?
Sorry? Could include self-ID, but what was missing, what I see missing now, that I didn't fully understand back then, is the lack of safeguards and the fact that when it is an unhinged, unregulated process, it can impact enjoyment of rights by other groups of women, and that it can cause also real concerns for them. I understand that better now. I also, by the way, understand that not just for Scotland. I understand that for Spain, for example, that is also going through a process and where women have raised also similar concerns. I've had people write to me from Germany, where apparently a similar law will be adopted, and on other countries. So again, this is not an isolated incident, what we're seeing in Scotland, these concerns. It is actually a reflection of a wider concern that we see in other countries.
Okay, thank you. If we could now go back to Rachel Hamilton, please.
Reem, welcome. You mentioned that you had concerns with age. Do you agree with lowering the age from 18 to 16?
So, Rachel, I have one constraint in answering your question stipulated by the rules of procedure that we have as mandate holders, which is that before I communicate on something publicly, I have to engage the government on it. And by that, I also mean the UK government. And in fact, it is my intention to actually dig my teeth into this, because I've been approached by either parents of children that, have transitioned and feel there were no safeguards about the way they transitioned. And as we know, most of these are actually girls, so they do fall under my mandate. So I have the intention really to look at this more closely. But I made the reference to it because I know it's a big area of concern that others have expressed themselves on. And of course, very legitimate concerns, I can say that.
Yeah, thank you, Reem, and I totally respect what you just said there. You advised the Scottish Government to, in your letter, to pause the bill But given that we will be voting on the bill over the next 2 days, do you personally have confidence that MSPs that are not part of this committee, not on this call, will have time to adequately consider the evidence that you're giving today?
So my job is to provide expert opinion on issues that I feel are very pertinent. And of course, I very much appreciate that many parts of the stakeholders in the Scottish Government, but also wider Scottish society, have engaged with me, have, reflected on the opinion, that it has been thought through. I would like to think considered. Whether they do so adequately is really not for me to say. It's really, something that they are accountable to Scottish society and the constituency that they represent. So I think that question is better answered by the people that the parliamentarians represent, and whether they will be happy with the way, the Parliament then makes the final decision on this.
You also raised concerns in your letter that the views of women's groups and others critical of the bill had not been adequately considered in this bill. Do you think that these last-minute committee sessions has done or will do anything to rectify this, in your view, particularly for the women that you discuss who feel that their protections are threatened by the potential of predatory men accessing single-sex spaces, or indeed their concerns around spaces becoming mixed sex and then women being self-exclude or choosing to self-exclude?
To be frank, I am not aware of every single proposal or amendment that is being used. I know that you are really at it quite judiciously, and of course, time is of essence. I still feel that speed, perhaps, or the need to pass something seems to still be more important than quality and outcome. But again, as I said, this is really not for me to judge. In the end, I just present my my opinion. And it's really up for these women, including, for example, those from minorities, and that you therefore have spoken to say whether these last set of adjustments really answer very seriously their concerns, whether they address them or whether they're cosmetic. I actually don't know what the latest shape of the reform bill looks like.
Okay, that's fine. Thank you, Convener.
Okay, thank you. And Karen, apologies, I saw I was cutting you off and transferring over to Rachel just slightly too early. So Karen Adam, please.
Oh, thank you, Convener. No, it was just to follow up and just ask Reem, when she noted, when I asked what had changed her opinion on certain aspects of it, and she said she was seeing it from all over the world, it was concerns. But I'm just trying to really get to the bones of this. Is that concerns with evidence to back it up, or is it just solely the concerns that you're listening to that made you change your mind?
I've seen evidence. It's not concentrated in one place. I've seen, reports also in the media by individual service providers, by organizations, testimonies by victims. As again, they're not all on the same website, so to speak, or you cannot just go to one place and find them. But that's also how we work, right? I mean, this is also outside of this issue. This is how I work. I'm approached by victims, victim organizations. They present evidence, and here evidence, what counts as evidence is also their lived experience. So I think, we sometimes disregard that. But as I said, when there is a lack of data or barriers to documenting and verbalizing your concern, and that's why, what has been referred to as cultural war is really not a cultural war. It's about, it's a human rights issue. It's a right to be able to have your needs heard and concerned and addressed. That for me is evidence. And then, of course, I weigh the elements they provide. I weigh the issues that are at stake, but also the rights that are at stake and the relevance to my mandate. So, I mean, there are so many issues where, you know, I have not seen, let's say, studies or research done on a particular experience of violence, precisely because of access problems or barriers. But that is very, very real because of the experience that victims and victim organizations have. And then through the interventions, the extent of it comes to light. And then you actually realize that if you scratch the surface, that there was a whole, you know, it was the tip of the iceberg, that there is so many stories, so many victims that have gone through so much and that have gone and knocked on every door, including the doors of their government, and nobody has listened to them, either because of political agenda, because of, you know, interests, because of lobbying, because of also criminalizing expression of opinion. So, yeah, so this is how it works, really.
Okay, thank you. And our final question from Emma Roddick, please.
Thank you, convener. Reem, as a survivor, I'm very aware that there's been a lot of reference to survivors' evidence, particularly with reference to rape crisis services. Do you acknowledge that this bill doesn't impact on how those currently operate? As Pam Duncan-Glancy outlined earlier, self-ID is currently the system used by rape crisis services in Scotland. And do you acknowledge that there isn't a single opinion amongst survivors on this issue?
I agree there is no one single opinion. I think the needs, as I said, the needs of those that are comfortable with gender-based spaces are addressed, because that is the overwhelming majority of service providers in Scotland. So I think there it really is not an issue. I also said that even before the GRA, there is already very real challenge in sort of working out practically as a service provider how you can exclude trans persons in a way that is legitimate and that falls within the exception category. Whether they have a GRA or not. The issue is, of course, that by making access to the GRC, by making access to a GRC easier, I think it's very reasonable to expect that you will get more GRC holders, and therefore that is going to potentially create also bigger challenges, whether on health services, as Victor said, but also on spaces that cater to women in their diversity, but also on spaces that should remain single sex. And, I mean, if you think of any, let's say, policy or law that grants extra rights to a group, we take it for granted that we have to regulate that, because we assume even if you make it easier, for example, for people to get handouts or to get additional loans or to get money. I mean, we know that there will be, if it's easier, you're going to get more people applying for it, and you have to manage that increase. I mentioned on the BBC interview that, there are so many things we go through in life that nobody questions when we put safeguards in or when we try to regulate it. Even, for example, refugees. I mean, someone is a refugee even before a government recognizes that they are refugees. So they are inherently refugees. But still, when they arrive at a country, there's a process to assess their credibility. There is a process to see if they fulfill the inclusion criteria of, being protected under the 51 Convention. Why? Because they will be entitled to other rights. I became Belgian last year. after 5 years, I was entitled to be Belgian. I felt Belgian, certainly, but I still went through a process where the government vetted whether I fulfilled the criteria of being Belgian, and had also safeguards in place. They asked for my criminal record. So I think we are more surrounded by these processes that have safeguards and that have different, elements to it than we realize. And so why should this be an exception? It doesn't violate the rights if we do it, in a, again, proportionate way, exceptional way. And we are not saying that it shouldn't be simplified. We're not saying they shouldn't have access to it. Of course they should. Because legal recognition is important. And of course, the current GRA should be reformed because it is too slow, it is cumbersome, it demands things that are not in line with international human rights. But it's it's sort of almost going from one extreme to another. And this is what this is about.
Emma, are you finished?
Convener, if I can ask a follow-up, I'd appreciate it.
Yeah.
Can I just pick up there? Would it not be right to infer from your suspicion that making this process easier would result in more people making use of it, that the current system needs this reform and that the reform is the right one to make?
As I said, the making it easier, of course, is fine as long as we take into consideration the impacts on other members of the population that have also their needs. I think there is clear evidence that the majority of violence against women or gender-based violence comes from male. Majority of sex offenders are males. And that they will use opportunities they can get in order to exercise this violence. Again, I think all of us have gone through an experience, I think given the prevalence of it, of either being exposed to sexual harassment or violence, even in spaces that we thought were safe because an opportunity presented itself, because the safeguarding was not tight enough. Just from a personal experience, I was in when I was in my 20s, I woke up from an all full body surgery to find a male nurse, groping my boobs. And it was a really horrific experience. Now, also, I did not report it because, women who go through these things do not report. So again, it's understanding also how when we go through these things, what the implications are. I tell you, I will never go back to that hospital, for example. Yeah, I will never go back to that hospital. I've had since then a fear of being, under anesthesia, and so it's coming back to the evidence. It's one case of violence because of the lack of safeguards, not good enough. This is a question I would ask about prisons. We know that there have been incidents of rape and violence by trans women placed in in female prison wards. So, has anyone done a study to ask female prisoners, how they felt about having trans women in their spaces? In some places it probably worked really well with some inmates. In others it didn't. But then it comes back to there is no evidence because we didn't ask the women. Nobody is inquiring from the women, but we have anecdotal evidence that actually these cases exist and that they're coming back to the guidance. When I asked Mrs. Shauna about this, she said, prison authorities, have sort of their own sort of SOPs for taking decisions on who they move into a prison, which male they move into a prisons. And I would argue that's not good enough. It leaves it very much to an ad hoc decision for prison authorities to make sort of these very important decisions but on an ad hoc basis, and they will make sometimes good decisions, but they will also make bad decisions.
Thank you. And just finally, because I am a non-member of this committee, I do want to recognise the amount of work that the committee's done over at least a dozen sessions like this in a hefty stage 2 debate. You did mention earlier that you believe this is being rushed. The bill has been 6 years in the making, 2 full-scale public consultations, and the committee has had so many evidence sessions and produced a very thorough report. How much more would have had to be done for you to consider the bill not rushed through?
Again, it's really not my place to comment on that, but I would say if after 6 years there is still this level of polarization and very, very strong feelings about it, and also feelings of exclusion of their points of view, then I think this is a reasonably good sign that there's still work that needs to be done. And now maybe it has to do with how suggestions are taken into considerations. Maybe it has to do with how, again, certain proposals are being addressed. But I think we would agree that there's to be still very, very strong opinions about this. Of course, there were also discussions in other countries. I think it's a question really for the Scottish constituencies, but I know from surveys that have been carried out also recently, I think for the Labour constituency, that it seems that 2/3 are opposed to the bill. So if that's any indication to go by, there's still work to be done.
Okay, thanks very much for that, and a huge thanks, Reem, for taking the time out. And apologies for keeping you waiting a little bit, and apologies for over and staying in the session, but that's a really great hand. Thanks. So thanks very much, everyone. The meeting is now ended. Thank you.